Good morning, students. Today, we will see the balance portion with regard to the performance of the contract. So, attempted performance of tender where one party, means maybe the promisee, doesn't accept or refuses to accept the promise made by the promiser. Then in such a case, it is called an attempted performance. Then we see essential characteristics of an attempted performance or a tender. Then who can perform the contract? Maybe the promiser or the agent of the promiser, otherwise any third party, or in legal representative in case of the promiser's death can perform their contract. Then yesterday we see what is the devolution of the rights and liabilities, and a tender can be devolution of the rights and liabilities. Under that, so I'm going to share for you the balance portions. So who shall perform the contract? Then time and place of performance, where to perform the then we see in the previous class where to perform the performance of the contract, where application is not forwarded or the date or the time is not specified, then the promiser allowed himself need to perform, inform the promisee, and then he need to perform his duty at a particular time and a place need to mention or place need to inform. That is the first case. Second is time is specified but no application is to be forwarded. In such a case also the promiser what to do, inform the promisee, because within the stipulated time period need to do the performance. And the third is what? Application as well as the date and time is also to be prescribed. So the promisee in such a case what to do? Need to finish his duty, means in with the presence of the promiser, and the promisee inform the promiser that to within that stipulated time period need to perform the duty. And place of performance where neither application is required nor a place of performance is fixed. In such a case, a particular place is to be fixed by the promiser and inform the promisee to do that such thing. Adana adutha case varna. Pinneyo promisee of course involved in this performance of the contract. Then in such a case, performance prescribed by the promisee means what? Duly his or her duty is to be performed. Then we see the devolution of the rights and liabilities where joint performance. ഒന്നിൽ കൂടുതൽ ആൾക്കാർ പ്രോമിസി ഒന്നേ ഉള്ളായിരിക്കും, അല്ല പ്രോമിസി ഒന്നേ ഉള്ളായിരിക്കും, പക്ഷെ പ്രോമിസേഴ്സ് കൂടുതലുണ്ടായിരിക്കും. സോ ദാറ്റ് ഈസ് ജോയിന്റ് പ്രോമിസേഴ്സ്. അപ്പൊ ജോയിന്റ് പ്രോമിസേഴ്സിന്റെ ഇതെന്നാ പറഞ്ഞേ? ജോയിന്റ് പെർഫോമൻസ് ബൈ ഓൾ ദ പ്രോമിസർ. എല്ലാ പ്രോമിസറും കൂടെ പെർഫോം ചെയ്യുകയാണെങ്കിൽ എന്താ? ദേ നീഡ് ടു ഡു ദ ഡ്യൂട്ടി ബൈ their own. അവരവരുടെ ഡ്യൂട്ടി അവരവർ ചെയ്യുക എന്നുള്ളതാണത്. Then joint promises may be compelled to perform by one person. ഒരാള് ചെയ്യാനായിട്ട് പറയുകയാണെങ്കിൽ. So one person need to joint promises may compel one person to do such a thing. Then that is this case. Joint promiser may be compelled to perform. Then in such a case, there is no express contract to the contrary, and the promisee may compel any one or more of the joint promises. ആരെയെങ്കിലും കമ്പൽ ചെയ്താൽ മതി. അപ്പൊ ആരെയെങ്കിലും കമ്പൽ ചെയ്താൽ അവരെന്ത് ചെയ്യും? ആ ജോയിന്റ് പ്രോമിസറിൽ ആരെങ്കിലും ഒരാള് they can do their own duty. അതാണ് സെക്കൻഡ് കേസ്. പിന്നെയോ ഇനി അങ്ങനെ കമ്പൽ ചെയ്യുന്ന കേസിൽ മറ്റേ ആൾക്ക് നഷ്ടം സംഭവിക്കുന്നുണ്ടെങ്കിൽ they can claim contribution from the other promiser. അതാണ് നമ്മൾ ഇന്നലെ കണ്ടത്. they can claim contribution from the other promiser. മറ്റേ പ്രോമിസറിന് എന്ത് ചോദിക്കാൻ പറ്റും നമുക്ക്? മറ്റേ പ്രോമിസറിന് they can claim a contribution. So in such a case, he remain. Then if any one of the joint promiser compelled to perform the whole of the promise, he may require the other joint promisers to contribute equally with himself to the performance of the promise. ഇപ്പൊ 3000 രൂപ എയും ബിയും സിയും കൂടെ ഡിക്ക് കൊടുത്തില്ല. അതായിരുന്നു നമ്മുടെ എക്സാമ്പിൾ പറഞ്ഞത്. ഡിക്ക് കൊടുക്കുകയാണ്. അപ്പോ ഡി എന്ത് ചെയ്തു? ഡി is the promisee. Promisee may compel any one of the promiser. So suppose C, and the C need to get equal share from A and B. അതാണ് പറഞ്ഞതിന്റെ അർത്ഥം. Right to claim the contribution. Clear? Then next is what? Sharing of loss arising from default. sharing of loss arising from default. അങ്ങനെ ഒരു കേസ് വരികയാണ്. അതായത് പ്രോമിസി ഇങ്ങനെയുള്ള പ്രോമിസർ എന്ത് ചെയ്യുന്നു, പ്രോമിസറോട് എന്ത് ചെയ്യുന്നു, compel to perform the duty. In such a case, any one of the joint promisor may do the duty and he need to incur some loss because any one of the joint promisor becomes insolvent. പാപ്പനായി പോവുകയാണെങ്കിൽ then the other joint promisor can equally share what loss is occurred there. അതാണ് പറഞ്ഞത്, sharing of loss arising from the default. And finally, release of a joint promisor. What is the release of a joint promisor? A release by the promisee of any one of the joint promisor does not discharge the other joint promisors liability from liability. ആരെയും ഒഴിവാക്കുന്നില്ല, ബാധ്യതയിൽ നിന്ന് ഒഴിവാക്കുന്നില്ല, അതാണ് പറഞ്ഞത്. Okay, so in such a case, the released joint promisor continues to be liable to the other joint promisors also. He is continued to be liable, ബാധ്യത ഉണ്ടാകും. അപ്പൊ ഇതാണ് devolution of a joint liability എന്ന് പറയുന്നത്. പിന്നെ നമ്മൾ കണ്ടു എന്താണ് time as the essence of the contract. അതായത് സമയം എന്നുള്ളത് വെളിപ്പെടുത്തിയിരിക്കുന്നത് അതിന്റെ കണ്ടന്റ്, മെയിൻ കണ്ടന്റ് ആണ് ആ കോൺട്രാക്ടിന്റെ. അതായത് ആ സമയത്തിനുള്ളിൽ ആ ഡ്യൂട്ടി ചെയ്ത് തീർത്തിരിക്കണം, അതാണ് ഓർക്കേണ്ടത്. So time as the essence of the contract. So when two persons enter into a contract, they may agree to perform the obligation at a specified time. ശരിയല്ലേ? ഒരു പർട്ടിക്കുലർ ടൈമിനുള്ളിൽ ആ ഒരു ഇത് തീർത്തിരിക്കണം. If the contract could not be performed within the appointed time, what would be the effect of that non-performance? എന്താണ് അതിന്റെ എഫക്റ്റ്? So then in such a case there is some clause to this act, time as the essence of the contract. First case is what? When time is the essence of the contract. Time ആണ് ആ പർട്ടിക്കുലർ സമയത്തിനുള്ളിൽ ആ ഇത് ചെയ്ത് തീർത്തിരിക്കണം. അങ്ങനെ ഉണ്ടെങ്കിൽ then time as the essence of the contract. In a contract in which time is the essence of the contract, if there is a failure on the part of the promisor to perform the obligation within the stipulated time, the contract becomes voidable at the option of the promisee. പ്രോമിസിയുടെ ജൂറിസ്ഡിക്ഷനിലാണ് അല്ലെ, പ്രോമിസി പറയുന്നതിനനുസരിച്ചാണ് പിന്നെ അത്. അതായത് ഒരു സമയത്തിനുള്ളിൽ പറഞ്ഞിട്ടുണ്ടെങ്കിൽ പ്രോമിസർ ഫെയിൽസ് ടു ഡു സോ, ഇൻ സച്ച് എ കേസ് വാട്ട് ഹാപ്പൻ, it becomes voidable at the option of the promisee. Promisee can decide whether that thing will be a voidable one or a void. Promisee തീരുമാനിക്കാം. അതാണ് when time is at the essence of the contract. When time is not at the essence of the contract, in such a case, what is the issue? In such a case, the promisee is not entitled to avoid such a contract. Then, but if the failure to do so, the promisor has caused any loss to the promisee, then he can claim compensation for the same. അതിന് കോമ്പൻസേഷൻ ചോദിക്കാം. പക്ഷെ voidable ആകില്ല. ആദ്യത്തെ കേസ് പറഞ്ഞാൽ it is at the option of the promisee whether that contract becomes a voidable or not. So contract becomes voidable at the option of the promisee in the first case. Second case, when time is not of the essence of the contract. Time is not of the essence of the contract. Where time is not of the essence of the contract and the promisor fails to perform it within the specified time, the promisee is not entitled to avoid the contract. But if the failure on the part of the promisor has caused any loss to him, he can claim compensation. Adana second one. Third is what? Acceptance of performance at other than the agreed time. പറഞ്ഞ സമയത്തിന് അല്ലാതെ വേറൊരു സമയത്തിലേക്ക് അത് വെച്ച് ആ ഒരു ഡ്യൂട്ടി ചെയ്യുകയാണെങ്കിൽ claim, the promisee cannot claim compensation or for any loss arising from such non-performance. However, he can retain his right to claim the compensation by giving a notice to the promisor at the time of performance of the contract or accepting the performance of the contract. Promisee accept ചെയ്യുമല്ലോ, ആ സമയത്ത് അയാൾക്ക് പറയാം, ഒരു നോട്ടീസ് കൊടുത്തുകൊണ്ട് എനിക്ക് ഇത്രയും നഷ്ടം വന്നിട്ടുണ്ട്, എനിക്ക് പൈസ തിരിച്ചു തരണം. അതാണ് acceptance of performance at any other time other than the specified time or agreed time. So these are the time is an essence of the contract or not. ആ ഒരു ടോപ്പിക്കിനകത്ത് വരുന്നത്, അതായത് time is an essence. അങ്ങനെയെങ്കിൽ സമയത്തിന് വിലയുണ്ട്, അല്ലെ സമയത്തിനുള്ളിൽ തീർത്തിരിക്കണം. അങ്ങനെയെങ്കിൽ എന്താണ്? It is at the option of the promisee whether to whether that contract becomes voidable or not. അതായത് void ആകും, near future void ആകും എന്നുള്ളത് ആരുടെ ഇതിലാണ്? As per the option of the promisee, if the promiser fails to do the duty or obligation within the stipulated time period. Second point is what? Time is not of the essence of the contract. Appo promisor fails to perform within the specified time limit, promisee is not entitled to avoid such contract. But if any loss occurring based on the failure or to do the duty of the promisor, then he can claim compensation against that. Who? Promisee can claim compensation. While in the third case, he cannot claim any compensation if the this one at the stipulated time period, other than any time this promisor do the duty. In such a case, he cannot claim, the promisee cannot claim what? Any compensation against the loss arising from such a thing. But he can claim compensation by giving a notice at the time of accepting the performance. അതാണ് മൂന്നാമത്തെ പോയിന്റ്. ഇതുവരെയാണ് നമ്മൾ കണ്ടത് previous classes. ഇനി next is what? Appropriation of payments. What is that? Appropriation. Add up. Payments എല്ലാം കൂടെ add up ചെയ്തു വെച്ചിരിക്കുന്ന കേസ്. So when a debtor owes several debts to a creditor, കുറെ ഉണ്ട്, കടമുണ്ട് എങ്കിൽ, and later if he make a payment insufficient to clear the whole debt, a question arises as to which particular debt this payment has to be appropriated. ഏത് പേയ്മെന്റിന് അഗേൻസ്റ്റ് ആണ്, ഏത് കടത്തിന് അഗേൻസ്റ്റ് ആണ് ഈ പേയ്മെന്റ് എന്നുള്ള ഒരു ഡൗട്ട് വരും. അതാണ് അപ്രോപ്രിയേഷൻ ഓഫ് പേയ്മെന്റ്, ആഡിങ് അപ്പ് ഓഫ് പേയ്മെന്റ്സ് എന്നുള്ളതാണ്. അപ്പം when a debtor owes several debts to a creditor, പല ഇതിന് several debts to a creditor, and later if he makes a payment insufficient to clear the whole debt, insufficient in clearing the whole debt, a question arises as to which particular debt this payment has to be appropriated. The rules relating to appropriation of payments is contained in sections 59 to 61 of the Act. So firstly, appropriation of payments. Appropriation of payments. So under that 59 to 61 അതാണ് ഹെഡ് സെക്ഷൻസ്. അതില് appropriation by debtor. Appropriation by debtor, where the debtor makes an express or implied intimation based on the debts to which his payment must be applied, the creditor must apply the sum to that specific debt. ഒരു പർട്ടിക്കുലർ ഡെറ്റിനെതിരെയാണെന്നുള്ള ഇന്റിമേഷൻ ക്രെഡിറ്റർക്ക് ഡെറ്റർ കൊടുത്താൽ, the creditor can allot that payment to that particular debt. അതാണ് appropriation by the debtor. Or intimation is given by the debtor to the creditor that I am paying this money against that debt. അതാണ് സ്പെസിഫിക് ഡെറ്റിന് അഗെയിൻസ്റ്റ് ആയിട്ടുള്ള പേയ്മെന്റ് ആണ് നടത്തുന്നതെന്ന് debtor is informing, giving an intimation as to the which debt I am going to pay. Then in such a case, the creditor must apply that particular payment against that specific debt. So that is the section 59. What is that? Appropriation by debtor itself. Appropriation by the debtor itself. Next, appropriation by the creditor. എന്ന് പറഞ്ഞാൽ എന്താ? കടം കൊടുത്തയാള്. Okay, appropriation by the creditor, where the debtor does not intimate at the time of the payment as to which particular debt the payment is to be applied, the creditor may apply the payment to any lawful debt. ഏത് നിയമപരമായിട്ട് എടുത്തിരിക്കുന്ന ഏത് കടത്തിനും അതിലോട്ട് അലോട്ട് ചെയ്യാം. Then the creditor may apply the amount even to a time bar debt also. സമയം കഴിഞ്ഞ ഒരു ഡെറ്റിനോട്ടും വേണമെങ്കിൽ the creditor has the right to allot that particular payment to that debt. ഒരു സമയം കഴിഞ്ഞ, അതാണ് സെക്ഷൻ 60, appropriation by creditor. Appropriation by creditor. So debtor does not intimating the time of the payment as to which particular debt the payment is to be made. കടം വാങ്ങിയ ആള് കൊടുത്തയാൾക്ക് no intimation is to be given about the time of the payment, when and where, what time, when and what time he will pay. He is not intimating. In such a case, the creditor has to apply such a payment to any of the lawful debt. ഏത് നിയമപ്രകാരം നിയമത്തിന്റെ ഇതിൽ ഏത് കടം കൊടുത്തിട്ടുണ്ടോ അതിലോട്ട് അലോട്ട് ചെയ്യുക. Maybe in such a case, whether it is allotted to a time barred debt, not a problem. സമയം കഴിഞ്ഞ ഒരു ഡെറ്റ് ആണെങ്കിൽ പോലും എന്താണ്, he can allot that thing. അതാണ് the creditor can allot. So that is the appropriation by the creditor. And third is what? Where the debtor does not intimate and the creditor fails to appropriate. Intimation illa, creditor allotting ചെയ്യുന്നില്ല, appropriate ചെയ്യുന്നുമില്ല. In such a case, what? Where the debtor does not expressly intimate and where the creditor fails to make any appropriation, the payment shall be applied in discharge of the debts in a chronological order. That is, in the order of time. If the debts are of equal standing, the payment is to be applied proportionately. ഒരേപോലത്തെ ഡെറ്റ് വരുന്നുണ്ടെങ്കിൽ it should be equally. 7,000 വരുന്നുണ്ടെങ്കിൽ കിട്ടിയത് ഒരു 7 14, കിട്ടിയത് ഒരു 10,000 ആണെങ്കിൽ 5 ഒരെണ്ണത്തിനകത്തോട്ടും 5 മറ്റേതിനകത്തോട്ടും. വേറൊരു ഡെറ്റ് കടം കിട്ടിയ കേസിലോട്ടാണെങ്കിൽ, സോ അതാണ് പറഞ്ഞത്, ഇറ്റ് ഷുഡ് ബി ഈക്വലി ഷെയർഡ് അങ്ങനെയുള്ള കേസിൽ. സോ ദാറ്റ് ഈസ് where the debtor does not intimate and the creditor didn't appropriate that payment. Appropriate means allotted. Adin against varavu vekkunilla engil, then in such a case what is happening? The payment shall be applied in discharge of the debts against the chronological order. ഏത് ഓർഡറിലാണ് എടുത്തിരിക്കുന്നത് ആ ഓർഡറിൽ എന്ത് ചെയ്യുന്നു? It should be apportioned. That is, in the order of the time, if the debts are of equal standing, സമയത്തിന്റെ അനുസരിച്ച് എന്നെടുത്ത കടവാണ്, it is under as per the chronological order, it should be apportioned. അതാണ് ഓർക്കേണ്ടത്. So if the debts are of equal standing, it should be apportioned or applied proportionately or equally. Okay, proportionate basis or any ratio is there, based on the ratio it should be apportioned. അതാണ് ഓർക്കേണ്ടത്. So appropriation of profits, അതിനകത്ത് pays not profit, payments, കിട്ടിയ പേയ്മെന്റ്സിനെ അപ്പോർഷൻ ചെയ്യുന്നു എന്ന് പറഞ്ഞാൽ അലോട്ട് ചെയ്യുന്നു. അതെങ്ങനെ? appropriation by the debtor. Debtor ആരെ അറിയിച്ചിരിക്കണം? ക്രെഡിറ്ററെ അറിയിക്കുന്നു, giving an intimation that I am going to pay against that debt. Then the creditor, what to do? Creditor is allotting that particular payment against that debt. That is section 59. Section 60 is what? If the debtor doesn't intimate and the creditor apportioning against the payment made by the debtor, then in such a case it should be apportioned or applied to any lawful debt that is to be taken by the which one? Debtor. Okay, so in such a case the creditor may apply that amount even to a time barred debt also. സമയം കഴിഞ്ഞ, സമയം വെച്ചിട്ടുണ്ടായിരുന്ന സമയത്തിന് അനുസരിച്ചുള്ള ഏത് കടമാണെങ്കിലും അതിലോട്ടും വേണമെങ്കിൽ അപ്ലൈ ചെയ്യാം. മൂന്നാമത്തെ കേസ് എന്ന് പറയുന്നത് എന്താണ്? Third is debtor does not intimate and creditor not apportioning. Creditor not apportioned. In such a case, what is the issue? The payment shall be applied to the discharge of the debt in the chronological order. Means if it is of equal at the based on the time it is taken. സമയം എടുത്തിരിക്കുന്ന സമയത്തിനനുസരിച്ച് എന്ത് ചെയ്യുക? It should be apportioned. So if the debts are of equal standing, the payment is to be applied proportionally. So this is the 3 cases where appropriation of payments by the creditor against the debts taken. Clear? So this is the appropriation of payments. So in continuation with that, appropriation by the creditor, debtor, and if the debtor doesn't intimate and creditor fails to appropriate, then this is the case in the chronological order. When the payment is to be made by the debtor, then the creditor need to add it. Means creditor need to take care of the against the payment. That is against which time this debt is to be taken. Then next topic is assignment of contract. Assignment of contract means what? The transfer. Assignment of contracts. Assignment of contracts. Assignment of contract means the transfer of the contractual rights or obligation by a party to the contract to some other person. വേറെ ആർക്കെങ്കിലും ഈ കോൺട്രാക്റ്റിന്റെ റൈറ്റ് അവകാശങ്ങൾ ട്രാൻസ്ഫർ ചെയ്യുകയാണെങ്കിൽ that is called assignment of contract. So assignment of contract means the transfer of the contractual rights or obligations by a party to the contract to some other person. Transfer of contractual obligation may happen either by act of the parties, ഒന്നെങ്കിൽ അവരുടെ act of the parties, or based on the law. രണ്ടാമത്തെ ഇതോ operation of law. So assignment of contracts means transfer of the rights to some other person. വേറെ ആർക്കെങ്കിലും ആ അവകാശങ്ങൾ ട്രാൻസ്ഫർ ചെയ്യുന്നു. So transfer of contractual obligation may have happening either by the act of the parties or by the operation of law. So assignment by the act of the parties. When a party to a contract voluntarily transfer his obligation or the right to another person who is a stranger to the contract, it can be termed as assignment by the act of the parties. So this person A and B is there. A is informing or A is transferring all the rights to C. Then C is a stranger to the contract. Then in such a case, it is called the assignment by the act of the parties. So party to a contract voluntarily transfers the rights to a person, another person who is a stranger to the contract. അപ്പൊ അതാണ് പറഞ്ഞത് എയും ബിയും കൂടെ ഒരു കോൺട്രാക്ട് ഉണ്ട്. എ എന്ത് ചെയ്തു? ആ പുള്ളിയുടെ റൈറ്റ് അവകാശങ്ങൾ പുള്ളി ചെയ്യേണ്ട കാര്യങ്ങളെല്ലാം ആർക്ക് കൊടുത്തു? സിക്ക് കൊടുത്തു. So C is a new person to the contract, stranger to the contract. So it is termed as assignment by the act of the parties. It may be due to the obligation or the rights. So this one obligation, the duties and also the rights. So this assignment may be either by obligation or by rights. So assignment of contractual rights and contractual obligation. Next we see that rights and benefits under a contract can be assigned unless the contract is personal in nature. For example, a creditor can transfer his right to receive the debt to any person without the consent of the debtor. Debtorയുടെ സമ്മതമില്ലാതെ creditor cannot transfer anything. So if the debtor consent is there, he can transfer his right to receive the debt to any person. അപ്പൊ അതാണ് rights and benefits, that is as per the contractual rights. അതിനകത്ത് പറഞ്ഞിരിക്കുന്ന കോൺട്രാക്റ്റിൽ പറഞ്ഞിരിക്കുന്ന അവകാശങ്ങൾ എന്താണോ അത് എന്ത് ചെയ്യുക? ട്രാൻസ്ഫർ ചെയ്യാൻ മറ്റേയാളുടെ കൺസെന്റ് വേണം എന്നുള്ളതാണ്. So the rights and benefits under a contract can be assigned unless the contract is personal in nature. For example, a creditor can transfer his right to receive the debt to any person without the consent of the debtor. That is the contractual rights. So next is what? Assignment of the contractual obligation. The obligation or the liability under a contract cannot be assigned except with the consent of the promisee. For example, a debtor cannot assign his liability without the consent of the creditor. Creditorയുടെ സമ്മതമില്ലാതെ debtor cannot assign his liability, transfer his liability. Debtor അയാളുടെ liability ബാധ്യത എന്ത് ചെയ്യാൻ പാടില്ല? ക്രെഡിറ്ററുടെ കൺസെന്റ് ഇല്ലാതെ വേറൊരാൾക്ക് കൊടുക്കാൻ പാടില്ല. അതാണ് the obligation. Obligation in the sense means the liability, and rights in the sense means the asset. ഓരോരുത്തരുടെയും എന്താണ് അവരുടെ കയ്യിലുള്ളത് ആ ഇത് മറ്റൊരാളുടെ കൺസെന്റ് ഇല്ലാതെ ട്രാൻസ്ഫർ ചെയ്യാൻ പറ്റില്ല. അതാണ് assignment of the contractual rights and contractual obligation. So once again we will look into that. Assignment by the act of the parties, where a party to a contract transferring voluntarily his obligation or the right to another person who is a stranger to the contract, it is called the voluntarily assignment of by the act of the parties. It may be through contractual obligation as well as contractual right. So what is a assignment of contractual right? The rights and benefits under a contract can be assigned unless the contract is personal in nature. For example, a creditor can transfer his right to receive the debt. കിട്ടാനുള്ള ഇത് കടം കിട്ടാനുള്ള അവകാശം ഡെറ്ററുടെ സമ്മതമില്ലാതെ മറ്റൊരാൾക്ക് ട്രാൻസ്ഫർ ചെയ്യാൻ പാടില്ല. അതുപോലെ തന്നെ ഒരു ഡെറ്റർക്ക് ക്രെഡിറ്ററുടെ കൺസെന്റ് ഇല്ലാതെ ലയബിലിറ്റി മറ്റൊരാൾക്ക് ട്രാൻസ്ഫർ ചെയ്ത് കൊടുക്കാനും അസൈൻ ചെയ്ത് കൊടുക്കാനും അവകാശമില്ല. അതാണ് രണ്ടും പറഞ്ഞത്, കോൺട്രാക്ട് ബൈ ഒബ്ലിഗേഷൻ ആൻഡ് കോൺട്രാക്ട് ബൈ റൈറ്റ്സ്. ക്ലിയർ? These two are the part with regard to the assignment by the act of the parties. അതിനകത്തെ പാർട്ടീസിന്റെ പെരുമാറ്റം കൊണ്ട്, ബിഹേവിയർ, their duty, that he can voluntarily transfer his rights or duties to any other person who is a stranger to the contract. That is called the assignment by the act of the parties. Next is assignment by the operation of law. So sometimes the transfer of rights and liabilities may happen based on the provisions of the law. In such a case, when it usually happens in the case of death of a person or due to insolvency. പാപ്പരായാലോ പ്രോമിസറ അല്ലെ പ്രോമിസി മരിച്ചു പോയാലോ ഈ കേസ് നടത്താം. By the operation of law, contract should be assigned. അതാണ് assignment by the operation of law. In case of death, when a party to a contract dies, his rights and liability devolves upon his heirs and legal representative. അവർക്കാണ് പിന്നെ അത് നോക്കി ഇതാകാനുള്ളത്. അപ്പൊ അതാണ് നിയമപ്രകാരം എന്താണ്, ഒരു പ്രോമിസറ അല്ലെ പ്രോമിസി മരിച്ചു പോയാല് based on that his heirs or legal representative can perform the duty. അതാണ് in case of a death of a person. While in case of insolvency of a person, his rights and liabilities may be transferred to the official receiver appointed by the court. ഒരു ആരെ വെച്ചിട്ടുണ്ടായിരിക്കും, officially a receiver should be appointed and he can receive that thing. അതാണ് operation by the law due to death and insolvency. Assignment of contract due to act of the parties, where contractual obligation is there and contractual rights is there, while due to the operation of law means death and insolvency of any of the person, either the promisee or the promiser. In case of death, what is happening? It can be performed by either by the heirs of the promiser or the promisee or the legal representative of the promiser or the promisee. While in case of insolvency, an official receiver should be appointed by the court and he can perform the duty. So this is the assignment of contracts. So today we see assignment of contracts as well as what is the appropriation of payments. Once again, today briefing, appropriation of payments in the sense means what? Who is going to perform the duty? That is assignment of appropriation of payments, where debtor owes several debts to a creditor and later on then he makes a payment insufficient to clear the whole debt. A question arises as to which particular debt, against what payment it should be done. Appropriation of payments, under that appropriation by the debtor, appropriation by the creditor, as well as the debtor is not intimating and the creditor is not also not apportioning. So in what way? Appropriation by the debtor in the sense means appropriation in the sense by the debtor makes an express or implied intimation to the creditor that I am going to pay this much money against that debt, then the creditor against that debt this to be appropriated. That is the case with the appropriation of payments by the debtor. In case appropriation of payments by the creditor, what is that? It belongs to appropriation of payment by the creditor in the sense means debtor is not intimating and creditor is taking appropriation of the payments made by the debtor, then he can against any debt to be apportioned. The creditor can make any debt apportioned by this one. Payment made by the creditor, the debtor, against that, what is the debt payment is to be applied. The creditor may apply to the payment to any lawful debt, and in case it is a time bar debt, that also should be done. So that is the appropriation made by the creditor, even then there is no intimation from the debtor. While third case is what? Debtor does not intimate and the creditor fails to appropriate. In such a case, making the payment by the debtor, the creditor may, in the chronological order, it can discharge against the debts made. So that is the third one, based on the order of the time or in the chronological order, it can be apportioned. So that is the three cases: appropriation of payments, appropriation made by the debtor, made by the creditor, and both the cases they are not taking. If the debtor is not intimating and the creditor is not apportioning, then it should be done on a chronological order. So this is the case. And then assignment of contract, transferring the rights from one person to another, that is the assignment. It means assignment or transfer of rights or duties to another person, that is the assignment or transfer of contract. So it may be made by the act of the parties, it may be made by the operation of the law. By the act of the parties in the sense means voluntarily transfer his obligation or right to a stranger to the contract or a third party to the contract who is a stranger. In such a case, assignment of contracts by the act of the parties. It may be contractual obligation as well as contractual rights to be transferred. That is the two part with regard to this one, act of the party. Contractual obligation as well as contractual rights. Another case is what? By the operation of the law. Operation of the law in the sense means what? Through law, niyama prakaram, enforceable by law. That is, in case of a death of a promisor, its heirs or legal representative need to perform, while in case of an insolvency, an official receiver appointed by the court to perform the duties. So, these are the main content with regard to which one? Performance of the contract, where attempted performance or tender, who can perform the contract, and who can perform the contract. Then we see the devolution of the joint rights and liabilities. What all there in this chapter? Devolution of the joint rights and liabilities. Then the time as an important content with regard to a contract or not, and also appropriation of the payment, and finally assignment of contracts, like this one, by the act of the parties and also by the operation of law. Where the act of the parties, it includes the contractual obligation to be passed, the liability to be passed, as well as the contractual rights of the or the duty to be performed, that also to be passed to any person. And also by the operation of the law, maybe the death or insolvency of the promisor. In case of a death, the legal heirs or the legal representative need to be taken care, while in case of an insolvency, an official receiver appointed by the court to be taken care. So with that, going to conclude this chapter, performance of the contract. So we will start a new lesson, a new chapter in the coming day. So if anybody is having any doubt, please let me know. Thank you for the day.